Well, hello, Uncivil Law fans. I hope you're well. And we're here with a late night stream to catch up on the latest going on the Supreme Court. We already covered this a little bit earlier today, but there have been a few developments and there were a few questions, and I thought I'd do a little bit stream to try to clarify some of this stuff. So, as we covered earlier today, the Attorney General of Texas has sued in the U.S. Supreme Court for a case for original jurisdiction. So that is a very fancy way of saying they want the Supreme Court of the United States to be the trial court. And they have sued Georgia, Michigan, Wisconsin, and Pennsylvania for violations of various election laws and said this is a dispute between states. So the United States Constitution in Article 3 grants original jurisdiction to the U.S. Supreme Court in various kinds of cases. Original jurisdiction is a fancy way of saying they are the trial court. And one of the reasons that the Supreme Court does act as a trial court is when there is a dispute between states. So one state is suing another state. And so Texas has filed leave under the rules for original jurisdiction in the Supreme Court of the United States. So Texas has sued Michigan, Georgia, Wisconsin, and Pennsylvania. And then, because everyone has to get in on the pile, because the pile, everyone has to get in on this thing, Texas has been joined. So now it is Texas, Louisiana, Arkansas, Alabama, Florida, Kentucky, Mississippi, South Carolina, and South Dakota versus Georgia, Michigan, Wisconsin, and Pennsylvania. So everyone has sued everyone. All the states are suing each other in the United States Supreme Court for original jurisdiction. How super exciting. And they've written a 154-page memo, which comprises the lawsuit and the brief in the lawsuit. And they've asked the Supreme Court to hear this thing. And the Supreme Court has asked they've asked the states that are being sued for a response by Thursday at 3:00. Now, this is the kind of thing that puts a horror into me, because I've never tried to write a Supreme Court brief, period. I've never had the pleasure. I've done it, in simulations, but never the real thing. And the idea of trying to write a Supreme Court brief in 2 days is giving me panic attacks. I know these people are good, but that seems impossible. But I know they're going to try, and I'm sure they'll do a good job. But the attorneys general of Pennsylvania, Wisconsin, Michigan, and Georgia probably secretly hate their lives right now. Not so much that they have to respond to this, but they have to respond to it in a 48-hour window. So they have to put together a Supreme Court filing brief in 2 days. So, you know what they're doing right now. I know what they're doing right now. They're sitting in an office somewhere, sipping on scotch and or coffee, hating their lives, and writing like mad. So that's super fun. Now, there has been a bit of confusion in the people who misunderstand this, because a lot of articles note that this case has been docketed, and that's true, but it doesn't mean anything. Docketing is just a clerical thing. It happens as a matter of course by the clerks. Every case that gets sent to the Supreme Court gets docketed. All of them. They all get docketed. They all have a docket number, and then the vast majority of them are denied. So docketing is not the same thing as certiorari. It doesn't mean the Supreme Court has agreed to hear the case. It doesn't mean anything like that. It just means it has a docket number now. And, you go from there. When you file a lawsuit in any court, you get a docket number. And the Supreme Court has given a docket number. So being docketed doesn't mean the court has agreed to hear it, but they have asked Pennsylvania to file a reply by Thursday at 3. So that'll be fun. So they've asked for the lawsuit. They've said basically, here's basically 154 pages, because I have skimmed it. I've skimmed the whole thing, but it's 154 pages. I haven't read it in detail. So here's what I understand them to be arguing, basically. They seem to be arguing in basic that a lot of these states have violated their own state laws and state procedures in various things that they have done. For example, they say that the Texas says that the various states have signature requirements, and the state election executive waived those requirements, or they have witness requirements, so they have to be witnessed by someone, and they've waived those requirements, even though the statute doesn't allow for those kinds of waivers. So they've said that these state officials have violated the state law in various ways because they have done things that the state law doesn't allow them to do. Now, that may or may not be true. To figure out whether that's not true or not, is an issue of state law. So this is, again, because we're doing legal interpretation, and the masters of the state law are the state courts. So the state law on its surface seems to say you have to have a signature requirement, and you have to have witness requirements. And then some executive says, well, we're not going to do that. So the question is, can the executive do that? And that's a legal question. It's a legal question under state law. And so then to answer that question, you'd want to go to the state Supreme Court, and who would answer whether or not that's legal or not. And because it's ultimately an issue of state law and state interpretation, what does the statute mean? And also, are there any other statutes that give the executive various authority? So are they able to use, does the statute on its own term give exceptions? Are there other things in other sections that give the executive the authority, right? So you have to do an actual, legal analysis, like you would do as a lawyer. You have to do a legal analysis and say, excuse me, you'd have to say, does the election code give the authority to waive requirements? And if not, does some other provision of law give authority to waive requirements? And if not, did they exceed authority? And if so, what are the remedies for that? And those all seem like state law questions. And here's the ultimate thing that I think is tripping up Texas, or I think will trip up Texas at the end of the day. I just don't see how this is really a dispute between the states. The case for original jurisdiction is when one state has a dispute because another state has caused it some kind of harm. So normally, the kind of things that get original jurisdiction for the U.S. Supreme Court is when there's a dispute over a border, or there's dispute over water, or there's a dispute over restraint of trade, interstate commerce, because these several states can't restrict trade. And so if they're doing things to cause harm to another's trade, then that's another reason. But elections seem like, on their surface, things that are totally internal to each state separately, as the separate sovereigns. Because the U.S. Constitution says that every state, or the legislature thereof, shall direct the time, place, manner of elections. And so that seems to be completely internally focused. And as we've discussed many times, every state legislature could, if they're so inclined, just direct their electoral votes any way that they please, ultimately, because it's a matter of their discretion. So the thing that I'm sort of tripping over, and still having tripping over, and I've been thinking about this for a couple hours now, and I've been looking at other people's analysis on this, and the thing I'm still tripping over is I don't see how Texas says it has been harmed. How Texas has been harmed. How has any of Texas's interests been harmed? What harm has befallen to Texas? Did one of the states interfere with its elections? Did one of the states prevent one of its votes from being cast? Has one of the other states prevented its electors from being met or being heard or received, or disenfranchised the citizens of its state? So, no, none of those things happened. So what is Texas's standing here? Why is this a dispute between states? Just think of it like a person, because it basically is a person in this context. So just treat Texas, the state, as a person. So how have any of Texas's, as a person's, interests been hurt by anything happening in Pennsylvania? And it's like, okay, maybe Pennsylvania did violate its internal law. Maybe its governors did violate the law. Maybe the election board did violate the law. But even if all that is true, even if illegal votes were counted, even if, whatever, how is that a harm to Texas? I don't know. I don't see it. So that's kind of where I'm tripping up. So my prediction remains where it was earlier today. I know that Barnes has been very optimistic on this. Barnes has been very optimistic on this. And I think other lawyers have been very optimistic on this. And Aviva Frey has even been optimistic on it. And I will certainly agree that it was well written and well documented. They did a very good job on it. So it was well done. I'll agree with that. But my prediction remains, despite the fact that it's docketed, which absolutely means nothing, it means F all. So people will say, well, it's docketed. That means they're going to hear it. It doesn't mean that. They've called for response. That means they're going to hear it. It doesn't mean that either. The Supreme Court calls for responses and then decides not to hear it. So my prediction is they will bounce the case. They will bounce the case. Now, in what exact mechanism that takes, I don't know. So will they just do it outright? Will they do it in a one sentence order? Will they grant it and then do like 3 pages, 4 pages, 5 pages of analysis? What form will that take? I don't know. But I think the substantive conclusion is going to be they're going to bounce it. So they might do it as a one sentence thing and say that's just denied. They might do it in 5 pages as a per curiam. That's probably a little bit more likely. They do it as per curiam, say these states don't have standing. Texas doesn't have standing to whatever happened in Pennsylvania. Whatever happened in Pennsylvania is an issue for Pennsylvania. And Texas can't bring it up because it didn't harm its citizens. It didn't harm its electoral votes. So I think it's a non-starter. I still think it's a non-starter. I don't think it's going anywhere. So Pennsylvania will respond on Thursday, and the Supreme Court may very well. Monday is the day the Electoral College is supposed to meet. So if the Supreme Court is asking for briefing on Thursday at 3:00, that means that you're looking from a decision from the Supreme Court by the end of the day, Thursday or Friday. So we probably will not pass this week without knowing for sure. So you probably look for a decision by Friday, if not late Thursday, because that's the kind of speed that the courts are running at right now. And so I think that it's going to be bounced, whether it's bounced in a one sentence order or whether it's bounced in a 5-page per curiam. I don't know. But the ultimate thing is like the ultimate reason beyond standing. So standing is a real problem because how have you been harmed? Redressability is a real issue. What do you really want us to do about it? And then the ultimate issue is the Supreme Court just doesn't want to inject themselves. The Supreme Court is a legal branch, and this has pretty serious political repercussions. And so I seriously doubt the Supreme Court wants a piece of this. So I think that you're very likely to get it bounced because why would the Supreme Court get involved this late at this hour and try to do something that's going to create a major political problem and also institutional legitimacy? It's in the Supreme Court's incentives to bounce the case. So I think they have really good reasons to standing. I think standing is a real problem for Texas. So I don't see this going anywhere. So all the people who thought that this being docketed meant something, it doesn't mean anything. Every case gets docketed. To the people who said that they called for a response, they call for responses all the time. Doesn't mean they're going to do anything with it. So I wouldn't get too excited. I don't think anything's going to happen. I know a lot of other lawyers are very bullish about this. They think that this is going to be the case that's going to crack the thing wide open. But I think the Supreme Court's institutional incentives are just not there, and it's the legal framework is just not there. So I really don't think they're going to get involved. So and that's kind of where we are at this point. So I'll take a few questions and then I'm going to get to bed because I just thought I want to be. I thought I'd clarify where we are in this thing, and of course, if something changes, if the Supreme Court does something unexpected, we'll cover that too. So, I'm just trying to predict based off speed reading 150 pages of brief. I'm trying to predict what I think will likely happen. And I'm also looking at this from a pragmatic incentives and institutional incentives view. And I just don't see the Supreme Court getting involved at this hour. And if they do, it's going to be like 5 pages per curiam opinion. It's going to be like, yeah, they don't have standing. It's internal issues. Those are whether or not they're violations of state law is issue for the state courts to resolve. And you're trying to dress this up as a federal issue, and it's just not there. So, yeah, I know other conservative lawyers think the lawsuit looks promising. I just don't think it's likely. I think the incentives are not there. Original jurisdiction isn't discretionary. As such, original jurisdiction isn't discretionary, which is why a per curiam is more likely, like a 5-page per curiam. So, yeah, it might not be discretionary, but they can grant it and deal with it in a 5-page. So they can grant it and then immediately dispose of it. There's nothing that they're particularly required to do. And they could always say this isn't really an original jurisdiction case. It's dressed up that way, but it's not really an original jurisdiction case. So, what you put on the label isn't what it is, right? So I think they could still dismiss it. I think they could dismiss it outright. Because, yeah, they don't have discretion over original jurisdiction cases, but that preassumes that it's an original jurisdiction case. And just because Texas says it's an original jurisdiction case, and just because it's a whole bunch of states suing a whole bunch of other states, I don't know that necessarily means it is an original jurisdiction case. They certainly try to put it on the label that's an original jurisdiction case, but Matt, you should know well enough from enough cases that we've covered on this channel that what you put on the label doesn't necessarily matter. What really matters is what it is. And so Texas can say, oh, it's a bunch of states versus a whole bunch of other states, therefore it's original jurisdiction. I'm like, yeah, but it's not really that. So I think the Supreme Court could dismiss this as it's not really original jurisdiction. And even if they grant it as original jurisdiction, they can say, yeah, we grant it and immediately dispose of it. Because the Supreme Court can do that, right? It's one of the benefits of being the Supreme Court, yeah. It is unbelievable. DASM says it's weird to request a follow-up in this time frame. It is unbelievably weird to request a follow-up in this kind of time frame. The idea of writing a brief before the Supreme Court in 48 hours is freaking me out. It would take me 6 months to write a brief to go to the U.S. Supreme Court. The idea of doing it in 48 hours, I want to cause harm to myself at that point, trying to do it in 40 hours. You want me to take a 6-month process and try to put it into 48 hours. It's like, no. Doesn't asking for defendant's brief indicate they'll grant certiorari? No. They ask for that kind of stuff all the time. It doesn't indicate that. Yeah. Does Texas get a First Amendment complaint? No. Definitely not. Not that they have to. It was written really well. It just doesn't go anywhere. I think their legal theories are flawed. So I don't think it goes somewhere. What about the UCC? Really? No. But thanks for playing at home, on the UCC. Yeah. Yes, the Texas voters were disenfranchised by illegal votes in that state. That's not right. Texas voters were not disenfranchised by illegal votes in other states. That's not even possible. To say that you are enfranchised or disenfranchised is to say, was your vote hurt? If your vote was counted, you weren't disenfranchised no matter what happened elsewhere. So, Texas voters weren't disenfranchised. Their votes were counted. I voted in Texas. My vote was counted. It went through the process. Texas certified its election. Texas was not disenfranchised. That doesn't even really make sense. By illegal voters in a completely different state, that doesn't even make sense to me. So, no. It's harmful to Texas' economy? No. Bounce this case. Is this black-pilled crap? I don't know. What do you define as black-pilled crap, I guess? You tell me what black-pilled crap is, and I'll tell you if this is black-pilled crap, I suppose. UCC is not federal. UCC is state. Uniform Commercial Code is state. It's not federal. It's adopted in every state, except for Article 2 in Louisiana, as we recently learned. But it's not federal. The UCC is state level. Yeah, the UCC is not federal. It's adopted every state, so it's kind of practically federal, but on a technical level, it's not. It's just adopted by every state independently. Dub Stepper Brian says UCC has to be federal. No, it doesn't. It doesn't have to be federal. It's dealing with commerce and the recognition of commerce. The federal government could regulate it because it is interstate commerce. So the federal government could regulate it. That the states regulate trade, unless the federal government wants to. I mean, it doesn't restrain trade. It doesn't put up any barriers to trade. It doesn't prevent trade. In fact, facilitates trade. So yeah, the UCC is not federal; it's state level. I'll be sleeping in a minute. Nice NATO Wash band. NATO is eternally classic. Yeah, I do like the NATO. Yeah, I do like the NATO because it's light. You know, just put a light. Take off the metal band and just put on a NATO. So it's light. Yeah, it's nice. Thanks. What about Trump's executive order placing the elections under national security? What about them? Elections are a national security interest. So the federal government has an interest in checking in on elections, but what about it? But they're still state level because the Constitution makes it state level. There's a super chat. Mickey, some name, which Czech krona. Yeah, Czechoslovakia krona. Cannot it be so that the states acting unlawfully harms the integrity of the election as a whole, which harms Texas has the right to participate in? I think it's too attenuated. Personally. I mean, that's the idea that they're going for, but it's just too attenuated, in my opinion. Too disparate. This will overturn the election. It's over. I suppose we'll find out. Supreme Court is the Kraken. Yeah, it might well be the Kraken, but they're not going to do anything like that. Supreme Court demonstrates its own illegitimacy. I mean, I don't perceive it that way. I mean, the Supreme Court still has to decide legal issues, and if Texas doesn't have standing, that's a valid thing to say. If Texas doesn't have standing, then it would be illegitimate to grant the case. So basically, we can have multiple states as corrupt, and other states can't do anything about it. Yeah, yeah, that's right. Yeah, yeah. A state can be infinitely corrupt, and another state can't do anything about it. Yeah, that's correct. Yeah. Start discussing the amending the Constitution. If you want to amend the Constitution, that's perfectly fine. That's what amendments are for. Say they take it up tomorrow, what would you think then? I would do. Yeah, the UCC doesn't apply. This isn't a Uniform Commercial Code issue. Is there institutional incentive to rule against party threatening to pack the court? Not really, no, because it's too chaotic, I think. It's a shame you guys can't run elections like we do in Australia. I mean, Australia's system does have some advantages, particularly the fact that they have multiple. You can vote for multiple candidates in the same race, and they have preferential voting, so that's kind of nice. Yeah, a state can pass any law that they want as long as it doesn't break federal law, right? Well, yeah, I discussed the Trump executive order thing. The Gore issue in 2000, I did Bush versus Gore on my channel. I released a video on Bush versus Gore on my channel on election day. So if you go back to election day, and watch the video, I did Bush versus Gore. But Bush versus Gore came as a result because The Florida State Supreme Court issued a statewide recount without statewide criteria on how to conduct the recount, and different counties were therefore conducting things differently under a singular state authority. So it was a little bit because of the precise issues of Bush versus Gore. Certiorari means they have 4 judges that want a hearing. That's right. What are the limits to state sovereignty and election law? Rog Blagojevich was brought up on federal charges for trying to sell his seat. Well, that would be the problem. The bribery, right? So the bribery is a violation of law. But it's a violation of federal law. Does Alito have a spine? I hope so. Are the proceedings in an original jurisdiction the same as a normal hearing? It depends how they construct it. Not normally. Normally, in most normal cases, they assign a judge to hear the facts as what's called a special master, and then they deal with it afterwards. But in this case, it would look a lot like a lot of appeal. Do I know any state that allows voter registration for non-citizens in state level elections? In state level elections, not off the top of my head, no. Paxton angling for a pardon? I don't know about that. I did like to note in the case about affecting winning vice president in the election, therefore the person who breaks ties, as being the way the states were affected. That's an interesting idea. So that's an interesting idea. That's an interesting argument. Okay, so the argument there is that Senate represents the states. The senators represent the states, and the president of the Senate is the vice president of the United States. And so the states have an interest in who the president of the Senate is. That's an interesting idea. It doesn't quite work, but it's an interesting creative idea. So you can't deduct points for creativity, you know? How will I handle the rift of right wingers who will permanently believe the 2020 election is stolen? I mean, I think it's kind of a fool's errand to believe. I think, just turn out and vote more. I did cover the Pennsylvania dismissal. It was dismissal of the injunction, but I don't think it's going anywhere. Why isn't the election under one rule for the whole state? I don't understand the question. Bush versus Gore was a very unique situation. Usually in states, elections are not conducted under a singular state authority like that. Normally, in states, the elections are done on county levels, and they're even done sometimes on precinct levels. So normally, you have a whole bunch of disparate authorities that are conducting the election and counting and dealing with counting the votes and stuff and so forth and so on. What made Bush versus Gore unique factually was that because the state Supreme Court ordered a statewide recount, you suddenly had a singular state authority speaking for the entire state as a whole. And they didn't promulgate any regulations to try to deal with it. But Bush versus Gore made a point of saying that they weren't trying to decide if non-uniform authority was okay in the first instance. So they weren't trying to. They made a special point of saying we're not deciding whether or not like county level, precinct level authority for elections is okay. They simply said, in the event that there is a singular authority, because it's the state Supreme Court ordering this recount, you need to have rules that are uniform, and they didn't even try, and it completely wound up. So that was a problem. Mm. Why is it Trumpers can't accept Trump lost? I honestly don't know. So apparently, a Texas attorney general indicated in a security fraud case. Couldn't this be a run at them to try to get a pardon from Trump? Oh, maybe. I don't know. Yeah, I don't know about that, but I didn't get that, but that's a thing. As soon as I saw the video, I know Kurt was gonna make a juicy stream. Yeah, and Bush versus Gore was very very weird. Matthew says Bush versus Gore isn't presidential. Yes, it was, or precedential. It is precedential. It's just very it's very weird in its setup. Um, so, but it does get cited quite a lot. What is the chances? I think Pelosi will be president. Probably. I don't. I doubt it. Yeah, I doubt it. I think the Supreme Court. I think the Supreme Court asked for a brief Thursday. They're probably going to dispose of it Thursday night or Friday. I seriously doubt they go into the weekend. So I would not be. I'd be a little surprised if this doesn't get wrapped up by Friday end of business. Didn't Bush versus Gore assert the ruling was specific to Bush versus Gore? Not exactly. They did have a line in there that it was limited to the present circumstances, but I covered that. I covered it in my decision. It's just very. They made a point of saying they weren't ruling for like the way that normal elections are done with different counties and different precincts and different voting machines and different standards in different places. So it wasn't that it wasn't precedential. It was just very fact specific. So yeah, I'm pretty sure it was published. Yeah, yeah, that doesn't make sense, Matthew. How can I say the vote more when Biden got more votes than Obama? I mean, seriously, more people vote for Biden than Obama. Yeah. Did Louisiana join? I believe they did. What was the list of states? It was. I think Louisiana might have got. Yeah. Louisiana. So it's Texas, Louisiana, Arkansas, Alabama, Florida, Kentucky, Mississippi, South Carolina, South Dakota versus Georgia, Michigan, Wisconsin, and Pennsylvania. And I wouldn't be surprised if another state or two tries to throw their name into the pile by the time this is done. Yeah. So yeah, I think the odds are very likely the Supreme Court bounces this case. So if they do it in a one line order, maybe, but probably like a 5 page per current is probably what we're looking at. That'd be my expectation. That'd be my expectation. We're looking at a 5 page per current coming out end of Thursday or sometime on Friday. That probably says something like Texas doesn't have standing to raise these issues. Would be my guess. Can California join the side? Yeah. I mean, everyone's going to throw their name into the ring. Everyone into the pile. Everyone into the pile. Reminds me of the South Park episode. Everyone back into the pile. It's like, yeah, everyone back into the pile. I'm sure California will throw its name in. New York will throw its name in. Well, not exactly as a defense, but they'll write an amici. I know that for sure. Yeah, so they won't actually throw themselves in as a defense, but they'll write an amici. I know that for sure. So we'll get California or New York writing an amici on behalf of 25 states submitted Thursday around 2 o'clock. Yeah. If Viva has a video, Viva thinks it's well written. I think it's well written too. If he thinks that there's some real good stuff in there, I think it's real good stuff. I think it's the best written stuff we've seen by far. So whoever wrote this did a really really good job. And I don't know necessarily it was the Attorney General of Texas, but whoever wrote it did a really really good job because it was very very well written. It's one of the best legal filings we've seen thus far. You expect nothing less from the Supreme Court. But I think at the end of the day I think at the end of the day this is not really a dispute between states. So I could see the Supreme Court bouncing this. I could see the Supreme Court saying that they don't have jurisdiction. That'd be fun. So the Supreme Court saying that they don't have jurisdiction, that could definitely happen. This is not really in a case of original jurisdiction, so we don't have jurisdiction. That'd be fun. So yeah, we don't. So this is not really an original jurisdiction case. We don't really have jurisdiction. Go away, or standing. Or political question would be the other one. This is an issue that's committed to committed to the political branches, and if you think it's invalid, go talk to Congress about it. Would be the other way. So, yeah. So they bounce it on jurisdiction, they bounce it on standing, or they bounce it on political question. That sounds pretty likely. Yeah, every single state's attorney general's not sleeping for the next 48 hours. Yeah, that's right. Yeah. That's right. It'll be interesting. It'll be interesting when Barnes and Viva have their stream on Sunday, because I think by the time they have their stream on Sunday, this will already be over. So unless they do a midweek stream, so if they do a midweek stream, then Barnes can. If they do a stream like Wednesday afternoon, Barnes can say how the Supreme Court's going to grant this and how this is the crack and we've all been waiting for. But by the time they have their Sunday stream, I think it'll be all over. Because I just do not see the scenario where the Supreme Court is intervening on this. You know. Okay, yeah, that's cool. You can buy around me. That's great. Yeah. I see Barnes' argument that Texas does have jurisdiction because federal elections are contracts between the states and they're associated. Wow. No, I didn't see it, and no, that's again a unique idea. So they want to argue. So he wants to argue essentially that the U.S. Constitution is a contract, and every state is a member, and the other states, by violating their internal procedures, are in violation of the contract that they all signed on. So it's a federal case. All right. Well, we'll give Barnes points for creativity, but no, that's not going to work either. Does Texas have a chance at winning? No, I don't think so. I don't think they have a chance of getting heard, to be quite honest. So yeah, if they bounce on political questions, will that encourage Republicans to challenge the election? It might. It might. That'd be interesting. But it's hard to challenge it in the. It's hard. I mean, they do have the votes in Congress, but that's a big one to pull. What about Lincoln actions that were made into emergency law under Bush? I don't even know what you're talking about. I mean, Bush signed a lot of emergency actions dealing with continuity of government stuff, and I'm sure there's some of the stuff in elections had continuity of government, but that's not where we are. If Texas doesn't get heard, what precedent does it send? I don't know. If you want to win elections, get more people to vote. That'd be helpful. That'd be the precedent it kind of sends. Yeah. I'll do a couple more minutes of questions, then I'm going to go to bed. Is there any practical way to have this heard? No. Um, the problem is that you're asking for some huge stuff, and so you really need some huge stuff to come up with it. And yeah, I don't think there's really a practical way to have this heard, especially with the election isn't particularly close. Lest I remind you, Bush versus Gore came down to 530 votes. So it was really really close. You're talking about 80,000 votes in Pennsylvania, 130,000 votes in Michigan and Wisconsin. It's not close enough for this. They say it's a civil rights issue since black populations, so it's disproportionately affecting minorities. So they want to say that was racially biased. presumably in violation of the Voter Rights Act or the Civil Rights Act. Creative, but again, no. Yeah, these arguments are creative, but no. Equal protection is a hard one. I don't know if the Supreme Court makes anything that it's forward looking at this point. Anyways, yeah, I think I'm going to go to bed now. If you like this stream, please give it a like. As always, please give it a sub. We'll see if anything changes. We'll see if the Supreme Court winds up doing something unexpected. But I know Barnes is really excited about it. I know there are other conservative lawyers who are really excited about it. But for me, I mean, it was extremely well written. I certainly agree with that. But I think that you're going to lose this. I think you could very well lose this on jurisdiction. I think you could very well lose this on standing. That would be my money, is on standing. And then you could lose this on political question. So jurisdiction, standing, or political question. My money's on standing. You don't have an injury to you, versus any other state. So, yeah, I think standing is where my money is, and you could either see that in a one-liner or you see that in like a 5-page per curiam. So yeah, that's what I'm thinking. So you're going to see like a 5 to 8 page per curiam, end of business Thursday or sometime on Friday, before end of the day. So either it'll be very late night Thursday, or it'll be like end of the day Friday. So like 10 o'clock p.m. on Thursday or 5 p.m. Friday, and you'll have a decision from this. So I think you're looking to a 5 to 8 page per curiam, maybe with a dissenting opinion or two. But I would be a little bit surprised to see a dissent, actually, because why get involved? Although I could see like Kavanaugh writing something, or Kavanaugh Thomas writing something in dissent. But I think you're looking at a 5 to 8 page per curiam and a Thursday, late Thursday or end of business Friday. I think that's where you're sitting. All right, I'm gonna head off there. Until there, my friends. Cheers and goodbye.